Hey there, welcome to our AP Legal Zone podcast, brought to you by AP Lawyers. We are your top fix for all weekly law updates, including family, immigration, wills, and estates law. Just a friendly reminder, we are not your lawyers, and everything contained in this podcast is for entertainment purposes only and not to be construed as legal advice. Be sure to subscribe to our podcast so you can stay connected with any updates and get notified about our new episodes.
Hello, I'm Angela Princewill.
And I'm Sherine Abdi.
And today we're going to be talking to you about your financial disclosure obligations in family law.
Fun stuff.
Yeah, our topic is going to cover the materials that you need when completing your financial statements. And the consequences for not disclosing or for not providing these materials. By way of a brief background, if you're separating or divorcing and you have a claim for support, division of property or equalization, or if you're asking for exclusive possession of the matrimonial home and its contents, you're going to be required to prepare a financial statement if you're taking this matter to court. But even if you're choosing to negotiate with the other side, if there's support obligations or, property issues, you're going to need some financial disclosure for the lawyers to be able to have any meaningful settlement conversation. So financial disclosure is very important, right, Sherine?
Yes, and it's sometimes never ending.
Yeah, it feels that way, but we hope that with this podcast, we can share some of the materials that you would need. And so that when you're coming to see us, or you're going to see your lawyers, that you're prepared and you have all of the disclosure and you recognize that they're not necessarily crazy asking you for all this stuff.
Yes, and sometimes some of these documents, they take a little longer to get. So it's nice to put your mind to how you actually need to obtain these beforehand. So it's good that we have this podcast.
Exactly. So first one is, I want to think about it to conceptualize it. We're going to be grouping these into your income. So the documents that you need to prove your income, your assets, and your debts. Okay. And they're not going to be in any particular order of importance or anything. It's just three big headings. You need to disclose all your sources of income. You need to disclose every asset and every liability. And we're going to go over what falls under each category. So should we start with income?
Yes. So income, obviously, disclosure. If you have support obligations, you're going to need to, or even just Section 7 expenses, which are extracurricular expenses for the children and extraordinary expenses, you'll still be required to disclose your income.
Yes.
So your income, if you're an employed person, even if you're self-employed, but ultimately there's a different obligation for self-employed individuals. It's a more of a threshold for them. But if you're employed, you would normally be required to submit your notice of assessments for the last 3 years. Mm-hmm. Your pay stub, you usually ask for about 3 recent pay stubs. If you're unable to obtain those, sometimes a record of employment is just as useful.
Exactly.
And then your income tax returns, although not entirely necessary, I prefer them.
Yeah, I like the income tax returns for self-employed persons because it gives us a clearer picture of what your income truly is. So yes. We know that you can write off a lot, and there's nothing wrong with that. No one's trying to catch you doing something criminal. We recognize that there's different thresholds for what's acceptable for the CRA versus family court. So with income tax returns, we're able to tell exactly how much your revenue was and sort of some of the things that you could have written off as a self-employed person.
And rightfully so, but for family law purposes, we can actually
clawed back.
Yeah, we can claw that right back to your income. And sometimes people may say, you know what, my income's only, $20,000. And if we take a closer look, we find they're self-employed and they're deducting over $60,000, $70,000 of expenses. Some of them may be justified. Most of them,
yeah, I would say most of them are justified. But the test I use in deciding, well, when it's not my client and I want to claw back income is if you were self-employed, would you be able to deduct this expense? So let's take your vehicle, for example. Yeah. It's so basic. Like you can write off your vehicle, at least the portion that you use for your business, some of your gas expenses and things like that. Employees don't get to write off those expenses, even though they drive to work every day and also have to pay for a vehicle. So that's an example of a very valid expense that I would claw back depending on what side.
I think the most common one we claw back, I mean, without hesitation, are meals and entertainment.
Yeah. So, and it's again, it's reasonable. So it depends. If you're my client and you have huge meals and entertainment expenses, it depends on what industry you're in.
Yeah, so the nature of your work.
Yeah, I have had clients that are into public relations, marketing, and that are averaging $2,000-$3,000 every week, not even months, on entertainment. And I think it's appropriate, obviously.
Got to wine and dine to sell the deal.
Exactly. So but again, the challenge becomes if you're spending $3,000 and you're telling me you're making $5,000 in a month, then, I mean, if that's what you're doing, you might want to have a conversation with your financial planner. I'm not one, but it just doesn't make a lot of sense. But clearly, if you're making a lot of revenue for the business, I think it's reasonable to spend that amount to be able to attract business. I think it's customary depending on for that industry, and it applies to others. But Sherine, I wanted to add as well, like it's also worked the flip way for me. So when I've looked at some of my self-employed clients' income tax returns, I find that their business expenses sometimes is just too modest.
Yep.
And I've in those cases, I've also been able to argue that some kind of additional discount be applied to
and why
income.
Why that income is justified in the circumstance.
Because they're very conservative and this is more for higher income earners where you have a little bit more discretion and I don't want to go too deep into this, but if your income for child support purposes is over $150,000, then we're not necessarily bound by the guidelines. So in those cases, if I'm dealing with a self-employed person and they have a high income and they don't have a lot of business expenses, I have sometimes used that. I've sometimes made the argument on discounting their income and things like that. But let's not go there because that's a huge rabbit hole we're going to go. We could spend an hour just going in there. But the point is, so the different
disclosure obligations. So if you're self-employed, income tax returns, I mean the complete income tax returns. So I think that's a common miss. A common miss is that, I get provided with like a brief summary or the
summary page, and people think they've done.
And I'm like, no, I need to see the full. And these are like easily 30 to 60 pages, and they have all the schedules attached, so I can actually see exactly what you're deducting and all the benefits and credits that you get. So the income tax returns, notice of assessments for self-employed individuals. If you own a corporation, we'll be asking, as well as business and statement of income activities. So if you must keep track if you're a self-employed individual.
Yeah, I think most times that comes with their tax return, so that's helpful. But corporations, you gotta love those.
Corporations are probably, the disclosure is never ending sometimes because depending on the nature of your corporation, there could be a lot of different tax documents. But under normal circumstances, we would ask for the corporation's income tax returns, the corporation's notice of assessments, the corporation's financial statements for the past 3 years as well, and any
whatever we think is relevant.
Balance sheets.
I think if it's a corporation that's beyond, so I guess I'd like to draw the distinction between a one or two person corporation, like a professional corporation, or just a corporation for income tax purposes or family planning, versus an actual corporation where it's like 3 or 4 arm's length parties.
Yeah.
If you're in a corporation where you're part of it, you're a shareholder in a corporation, you don't have full control of the corporation in that sense, and you're dealing with many arm's length parties to some extent, then the disclosure obligation might be a little bit more measured. And I'm just adding this because I know some people might be concerned that, oh my God, I own shares in a few shares in whatever XYZ corporation, do I now need to go get all of this disclosure? Not necessarily.
Yeah.
This is different from corporations where, we're talking about maybe family corporations or corporation where it's tightly held, where you have some measure of control. Then we want to see your income, because you would generally in those situations have control over how much income you take home and how much is perhaps left in the corporation.
Exactly.
Or you even have control in those cases over how you take your income. And, if you talk to an accountant, you would, there's distinctions between taking your income as employment income versus as maybe dividend income. I know there's always changes, so I don't know how advantageous that is these days. But maybe, instead of taking payment, you're taking you're drawing money from the corporation as a shareholder loan, for example.
Yep.
So we want to see all that to be able to understand the true financial picture.
Yep. Sometimes the articles of incorporation are helpful as well. Mm-hmm. So yeah, that's a good way to summarize it.
There's a lot that can be required under the income category, depending on how you make your income, whether as an employee, as from drawing your dividends or income from a corporation that you control, or if you're self-employed.
Yep.
Okay. So, I don't know if I want to go any further into income on this.
I think that covers it enough.
Okay.
I think it's a good.
There's a lot more that we could talk about clearly, but I think you understand that you have to, provide every source of income. The other one that I really want to touch on is rental income. So that's another one where, a lot people could make a lot in revenue, but can possibly write off a lot. So we want to see.
Yeah. Sometimes when in that case, we would ask for the rental agreement. So that way we know if you're writing off a portion and, and then I want to see like the cost. So if you're saying, the mortgage, the utilities and all of that are not being covered by the rent that's being paid, and then it's not also being disclosed and on the actual tax returns, then you definitely want to claw that money back. And depending on if the rental property is held jointly, the other parties also are entitled to half of that rent as well.
Yes. Okay, so that's it for income and not so few words. So let's jump to assets now. So every asset you own needs to be disclosed.
And I think the most common misconception is the different assets that we'll discuss are actually called assets. So like your vehicle, it's an asset. Things that you normally wouldn't treat as assets are assets. They're not just money that's sitting in an account is an asset.
So you're going to need to show your bank accounts. Yep. Every bank account you own, even if every bank account you have, especially as of the date of separation, even if you close it after, we want to see what it was as of the date of the balance as of the date of separation. If it's a zero balance, please provide disclosure showing it's zero. Because many people just say, they don't disclose it.
They're like, oh, it's an inactive account. I'm like, it doesn't matter because they're going to see, sometimes you get a summary printout, which is usually what we ask as well. And then we will see an undisclosed account and they'll be like, oh, well, I don't use that account. I'm like, well, it doesn't matter. The obligation is for you to provide every account regardless of what it is and it's an activity, if it's closed.
And regardless of whether you owe, sorry, you were going to say especially what?
Oh, I don't even remember.
So I'm sorry about that. I cut your thought out there. But if it's another misconception people have is if it's jointly owned, they feel like they don't need to disclose it.
Yep.
Because sometimes so a common example is a lot of seniors and with all the baby boomers we have now, a lot of them planning their estates and things like that would have their children added on to as joint owners of the account. And you have to disclose that. We don't necessarily have to equalize that money because there's case law and decisions that have confirmed that in those cases, you really don't have a beneficial interest in the money. And that's, again, I'm not going to go into the legalese of explaining that. I would only say that it doesn't matter if you own the account alone or if you own it jointly with somebody else.
And you were just placed on the account for efficiency
let's disclose
purposes.
it. We don't have to share the money. And the reason why this is, I've had clients, like Sherine made a very interesting point with the inactive account. I actually had a client who did not disclose an account, and not because he was trying to hide anything. And it's like, oh, some account, he completely forgot about it or just didn't realize how serious the obligations are in family court. But then when we got the statements, he had about $68,000 in there. So yeah, so that's $68,000.
How do you forget about 68?
Because it had to do with it's an account that had to deal with an estate for a parent, and I think the estate is not completely wound up, and so it took us down this rabbit hole of having to see the will and having to see Eventually, it was upsetting for the client because it's not money that he believes is his or that he has to spend. He gets to spend every day. It made him look bad from a credibility standpoint, but we should have disclosed that account and we should have, then excluded it and said there's $68,000 in his name, but it's only because he's executor of this estate. So there's your bank account. We mentioned vehicles, boats. If you're leasing your vehicle, I should say, put it in there, but just put that it's leased.
The value doesn't actually get attributed. You don't really need to, especially if it's a lease.
Yeah. Investments. Yeah.
Stock options.
Yeah. I love stocks. I love stock options because that creates very interesting conversations. So your stock option is an asset, and I cannot tell you the number of times that I have had to be involved in this argument where one side feels they shouldn't be sharing the stock because they don't actually own it. So without giving a lecture on how options work, it's an asset. Okay. If you have an option, whether it's an option to buy corn at a certain price or an option, I wish I had options to buy corn, by the way. It seems like it's a hot commodity these days. If it's for copper, if it's to buy shares in that startup that you've joined, it has a value. And in some cases, the value is very minimal because if you have stock options in a startup, for example, that it might be worth nothing, right? But in some cases, if you're in an established company, it could be worth a lot.
Yep.
So we need to disclose it one way or the other. And there's ways around valuing these things. And I know there's a whole conversation around stock options. Is it restricted? What's the value and things? We will take care of that, but just disclose it to us because it looks really bad when the other side finds out and, your credibility then takes a hit. So again, disclose your investments, your stocks, mutual funds, all of that.
So like RSPs, really everything you can think of. RESPs, we disclose them, but we don't actually include them because they're usually held in trust for the children at that point.
Yes. Air miles. So if you have air miles, this is one that we rarely deal with because a lot of people don't acquire that much. These days with COVID, no one's traveling anywhere. But back in the day when people traveled a lot of salespeople, executives, things like that, they acquire a lot of air miles and families sometimes use these points to take trips and things like that. So they're very valuable. Aeroplan, I don't even know if that's still a thing. So if you have those kind of points, it's property, it's an asset that can be equalized. We can transfer some air miles over. We could give it a cash value. So if you have lots of points, let us know about it. If your ex has a lot of points, and we're talking a lot, like I collect points. I've been collecting air miles for several years. I don't even have enough to buy anything. I cannot buy anything with my points. So that's not the kind of points we're talking about here. I probably have $50 on my optimum card. That's not the kind of points.
I've never personally fought over including air miles or or Adventura points or anything for any point-based credit card or collectible point. Thankfully.
So, if you're fortunate enough to own an airplane, then you must know that's an asset.
Yachts, boats.
Collectibles are one that's always interesting. I don't like them, but they must be disclosed and we must find, and the only reason why I don't like them is because valuing them is so individual. So I cannot use the same person that would value, say, baseball cards sometimes to value records, for example. So
sometimes even, I think a lot of people might think like things like this are worth more than they think.
Yeah.
And then it turns out valuing them is actually more expensive than the actual thing they're valuing.
Yeah.
So we want you to be mindful. If something is an actual collectible, and if it has a value, that value is going to be attributed to you and may unnecessarily increase your net family property. So something you may want to consider.
Yeah, and well, for the other side, if you have special doll collections or
China sets, those antique furniture. I mean, I'm not one for collecting antiques, but I hear it's a big thing.
Yes.
So, I mean, it's something to keep your mind to.
Yeah. So just if it's yours, would need to value it. If it's your exes, then we need to just put our mind to it and make sure that they value it as well. So jewelry, I love jewelry because it's a big part of
it is a big part
of our work. Yeah, and it's interesting for a lot of cultures. Jewelry is always part of the claim because my understanding is it's something that's usually given either
it's given upon the marriage,
on the day of marriage, something like that.
And they're pretty valuable. And it's in some cultures you actually collect the jewelry as a form of, instead of giving cash presents or other items, it usually is gifted in very expensive gold or diamonds. So I actually recently had this issue come about with about over $200,000 worth of gold that the other side didn't disclose. Yeah. So that's an issue that we're dealing with now. Yeah. But definitely like things like this could have significant value, especially if, you collected them over a 30-year marriage.
Exactly. So, and then so if you have a business that may or may not have a value. So for businesses, we'll need a value, and usually there's business valuators that can value that. It's not in every case that we're not particular in every case, would be able to understand better if it's required from the nature of your business.
Not every business has per se a value.
Yes.
I'm sure it has a value to that person. But sometimes not a value
that we can assign for equalization purposes.
So let's say you're like an accountant and maybe you just recently opened up a business. Without you, there would be no business. So sometimes something like that might not have a very significant independent value.
Yeah, but then if you own
if you own
the new Facebook in town, then we may want to value it and split that the difference.
You have employees and you have tangible assets, things like that.
Yes.
It's more likely than not there's some sort of tangible benefit in that business where that can be valued.
Yeah. And if money is owed to you money is owed to you. It's an asset. So,
So money owed to you can be from like a settlement, from like an ongoing, let's just say you have like a civil claim and you think that you're going to be successful. Any property claims, really any court claims that you're thinking of, or even money owed to you from the government.
Yeah, but those are more clear cut. I always get concerned when people are like, well, her brother owes me $20,000 for that I loaned him how many years ago when he wanted to start his business, and it's been 10 years and I want him, and then they put it down, money owed to me, $20,000 to Bob from 10 years ago.
That's a more reasonable amount.
Please, no, don't do that, because
I know. Yeah.
If you put that, remember that money owed to you is an asset. When we're preparing your financial statement, the goal is to divide your property. So if we're dividing your property, now if Bob hasn't paid you back, if Bob, your brother-in-law, hasn't paid you back for the last 10 years.
And may never pay you back.
Chances he may never pay you back. So now you're going to share half of this money. You're going to equalize that amount that you may never receive.
Yeah.
So if Bob is your brother-in-law and you put that under money owed to you, that's you really want us to. If we're your lawyers, please let us know, because we want to be mindful of that so you don't overpay.
I know it may feel justified to put it in that column on the financial statement. X, Y, and Z owes me this, and then this, and my mom owes me like $30,000. trust me, it's not what you think it's doing. It's doing the opposite, and it's usually not the benefit to you.
Yeah. So, well, that's one. If we're working on your financial statement, we will pay attention to that. If you're doing it yourself, please pay attention to the effects of money owed to you and make sure it's one that's really reasonable. So if you're expecting, Sherine talked about the settlement, severance pay, for example. So, husband gets fired and he has a severance pay. Now they've separated and severance pay comes, 2 months after the date of separation. Well, we want to know that that's money. It was money that was owed to you as of the date of separation.
Yeah. So if you had a claim that arose before the date of separation, just because you received the payout after the date of separation, it doesn't necessarily mean that asset's not going to be included.
Yeah.
If that claim arose in the date of separation, you most likely will still have to conclude it. But again, depending on the nature of that, we as your lawyers would go over the circumstances regarding that kind of payout.
Yeah. And let's talk about household content, their assets. So this is your TV, your dresser, your
bed. I promise you, it's not worth what you think it is.
No, really, it's not.
So many times.
If you do a garage sale, you would realize how worthless your items are. It's crazy.
If you get anything,
it's crazy.
It's funny to me because I see even laptops, like a MacBook, and headphones, and I'm and an iPhone, and I'm just sitting here realizing these are assets that are going to be only increasing your net family property. But the reason we want you to be mindful is because these are not assets that would actually generate significant value to you. And for our purposes, what we like to do is essentially leave the household contents out.
Yes.
Unless they really have significant value.
And the truth is the courts, I've had the misfortune of being in a trial where we spent 3 days arguing about household content. And I promise you, I was not the one doing the argument on the household content, because the judge made it very clear that they really don't have the authority to assign a value. So, this is a trial spent on the value of china and on the children's beds and things like that. The judges don't have the authority to do that. If you have a very special item in your home that you think has a significant value and it's owned by maybe the other side, then what you want to do is get it valued.
Get it valued, or the judge would be forced to provide a value for something.
Most times they wouldn't. They would just ask you to divide it as is.
Yeah.
So that's why
party keep it something more simpler to that line. But
when I do financial separation agreements, for example, and the parties don't agree on household content, my simple way is flip a coin, and then you do a you pick, I pick situation. Yeah. So I pick the bed, you pick whatever, the china.
You get the master bed furniture, I get the guest room furniture. And then you get the upstairs TV, I get the downstairs TV. It's more simpler. And so in our financial statements, we don't include the value, we put to be divided in kind or something of that nature, so that you guys can put yourselves, if there is the issue of household contents and we found out later that there needs to be a value assigned, then we can deal with that.
We value that particular item. We don't think it's worthwhile to necessarily value the dressers because what happens a lot of times, and it's happened to be so many times, when my client is insisting on how valuable, maybe they bought a bedroom set so many years ago and
it was $20,000, and
they're thinking of how valuable it is, and they want to include, and maybe they're going to leave it in the home, and they're saying, well, you know what, I want it to be $15,000 or whatever. Seems reasonable, right? But then the other side says, you know what, come take it. If you think this is worth $15,000, come take it. Many times you're not even in a position to
attribute the value to yourself.
Yes.
So are you really doing yourself a favor? I feel like you're paying double then for your.
Sometimes you don't even want it. You don't want.
Sometimes you have to pay more to get rid of it.
Yes. So it's one that household content is one that people spend a lot of time arguing, and you just really want to be very strategic, because as Sherine said, you take $15,000 and now you have to pay the other side because the person says take it. and pay me out.
Yeah, and then maybe a year down the line, you don't even want it, and you're paying someone else to come pick it up.
Sometimes people don't even want it at that point in time, because if you have a bedroom set in a big master bedroom, and as a result of a separation, you've decided to downsize, and now you're living in a condo, it might not fit the aesthetics, the space.
Yeah, fair enough. I mean, and like the reality is sometimes it just. And
here we are spending a lot of time talking about household content.
In short, please consult if you're having difficulties and you really want to assign a value, please speak to a lawyer about it and whether or not it's worth the benefit, the cost versus benefit analysis in that circumstance, please.
Yes. Did we state the obvious that your house is an asset?
I don't think we touched on that. We went straight to house. Just know that the things in it may not have as much value, but the things that are the actual home that it's in.
And the fixtures on the home, for the most part,
has a significant value, and that is an asset. So if it's jointly owned, you'll put half the value, and if it's not, then you'll put that amount as well. But ultimately, your home, any foreign assets that you own, like foreign properties, they're also assets that you must include. So sometimes we would ask that maybe an appraisal over someone over there certified to go get the value for that property, to go get that appraised for those relevant dates on the financial statement. And so really, really foreign property, any interest in any property.
Yeah, any property at all. It might be a property where you're joint owner with somebody else.
Yep.
Then you need to include the 50% ownership interest
or if you have 25%, whatever interest you have, please don't leave out significant, because if we pull a title search,
you could see, property.
I mean, if it's in Ontario, it's in their jurisdiction. Obviously, if the party also knows the other party knows that you have a house in Florida that you just, omit to putting on your financial statement, I'm sure we could get the title documents for that. And it doesn't really look good to leave such a significant value out of your financial statement.
Another thing people often do as well is they don't. So if you own property with your older parents as well, please disclose it so that we have it in there. If you're not going to get that half, so again, for estate planning purposes, you might be a joint owner to a property. Disclose it. Again, at this point, and on our next webinar, we're going to talk about the actual equalization process. But today, we're just talking about your disclosure obligation.
And just because it's included, we want to add like a caveat. It doesn't mean that it's going to just automatically be included, and we're not going to make steps if it's property that's allowed to be excluded, which we'll talk about when we talk about equalization. It doesn't mean that we're just including it and, then you're going to pay them half the difference. Yes. It means disclose it. And then if it warrants, like for example, the estate planning purposes, you only had a beneficial interest
or an ownership
interest.
Yeah.
Then that's where we would be like, okay, that's something that we would potentially look at excluding from the value.
Exactly. So you know how in real estate they say location, location, location? Well, family law, disclosure, and more disclosure.
I don't think that's a perfect way to say it.
So, your life insurance is an asset. Well, not all life insurance, but regardless, just disclose your life insurance, okay? If it has a cash surrender value, let us know.
Yep.
If you look at your life insurance statements, you would know if it's a whole life policy. For the most part,
it always will have a cash surrender value. If it's a term policy, it actually never does that I've seen. If it's a special policy that's in place, again, just provide us with the policies. We'll look at it, and usually if their cash surrender value is undeterminable, we'll reach out to the holder of the policy and get those details.
Yeah. Pensions. So,
fun.
Yeah. So pensions is one of those. That's why, again, it's the importance of your financial disclosure obligations. The importance of thinking about it early on is it's important. Let me just put it simply. Because of things like pensions, if you have a pension.
But you're talking about pensions not in an RSP, right?
Yeah. So
I think that's a common misconception is like, oh yeah, I have a pension. And I'm like, that's easy. Like if it's an RSP, we'll get a statement. But if
you have a defined benefit pension or a pension that's a combination of defined benefit and defined contribution pension, then we need to get it valued. Why does this matter? It matters because under the Pension Benefits Act, they have the pension plan administrator is the person that's tasked with providing us with the valuation. And they have 60 days to do that. So we want to make sure that we put our mind to your disclosure obligations very early on. And if you have a pension, we don't want to have to wait 60 days to finalize
60 to 90 days, actually.
See?
So
we don't want to have to wait that long.
Yeah, you definitely don't, because especially if it's something that you guys maybe need a separation agreement and, the home is closing. And, you need
and then now we're scrambling because we don't know the value of your pension, and the lawyers can't do a separation agreement.
Yeah, we can't deal with the issue of equalization often because we don't know what the pension's worth. We don't know if you want to divide it at source. We don't know what the options are, but to be honest, it's still a value we have to technically go get value depending on the pension.
It's an asset and we need to know the value.
Exactly.
Yeah. The survivor benefits
interesting.
It's part of the pension. So if your pension is in pay, which I guess that says it. If you're
already receiving your pension at the time of separation, then your spouse, most often, more than not, is entitled to a survivor's benefit. And that usually is actually an asset to the spouse receiving it.
Not to you.
So not to the pension holder, but to the pension holder spouse.
Yes.
And they actually will attribute that as an asset to them. So something to look out for and keep mindful.
Yeah. And if you have benefits at your work, most benefits don't have a cash value, but some workplaces actually assign specific monetary values to your benefits. Or in some cases, I know we've had a file before where there were flex benefits from the employer where they got a particular dollar amount that they could spend on medical each year.
And like and specific categories, medical, like wellness, like different little categories that literally had a dollar value to them.
So it's an asset. We will disclose it. Obviously, we don't have to divide that because we could just argue that if you don't use it up, you don't really get it. But it is an asset because if you needed glasses, you could pay from that flex account, and that's $500 less than you're going to have to pay out of pocket. Point is, there's an argument to be made one way or the other. What's not arguable is that it's an asset that must be disclosed. And so what else? I'm just trying to think through various options. I think can you think of anything off the top of your mind? I'm pretty positive there's something that
assets, bank accounts, investments, GICs.
Yeah, we didn't mention GICs, but we know that. Anything that has value is an asset. Okay, just anything that has value, disclose it. And remember, your disclosure obligation does not equate to your obligation to divide it with the other spouse. You just need to disclose.
But not your kitchen table. We don't care about the value of your kitchen table.
Just call it your household content to be divided after. And so now we're done with assets, and we're in the last section, which are your liabilities. So, Sherine, do you want to run over some of the liabilities?
Yes. So your liabilities would ultimately be any mortgages. So if you have a property,
debts,
any debts. So anything that you're paying off for the most part. So mortgages, mortgage penalties to actually discharge the mortgage, something that you want to put your mind to. So if you have a matrimonial home, any investment properties, any other interest in any properties that hold mortgages. So the reality of debts that we include is because yes, you have the asset, but there comes a debt usually attached to it. And so it's not fair to equalize the whole value without decreasing it from the debt. So the net value of that asset. So mortgages, line of credits, any HELOCs, which are home equity line of credits that are attached to the home, also debts, any credit cards, any car loans,
income tax debt.
So if you're owing money at the date of separation to CRA for, the previous tax year, or for any other, I guess if it's rolling over from a previous year, but it exists on the date of separation, it's still a debt. If you owe $20,000 to CRA and, you pay it 20 days after the date of separation, it's still a debt that you get to actually include in your equalization, in the financial statement.
So loans from friends and family and things like that, they're debts.
But be mindful because some of these things may not actually be a debt just because they're, a loan and, but there has to be some sort of intention to repay that loan. But again, I won't go into the legalese of all of the, is it a gift? Is it a loan?
Exactly. It's a loan just tell us about it and we could deal with it at that time. If the other side also takes objection to it, we will deal with it. But at this point, we just want you to know the things that you need to disclose.
Yeah.
Legal fees to defend the matter is...
So not like the legal fees you're paying for your lawyer in that current state.
I believe that, yeah, absolutely. So any sort of legal obligation, even if it's unpaid. So if it's the particular case and so
let's say you're on ongoing civil suit or something that you've been defending.
Or even in your family law matter. If it's unpaid and you're owing that lawyer, then it's...
On the date of separation, 100%. I mean, you can disclose
even
it on today's date, but today's value will only do so much. It actually does nothing for you.
Nothing for you.
It's just there for, I guess, aesthetics, but also it can be used to determine a party's ongoing financial circumstance. But for equalization purposes, you're more paying attention to the date of valuation, which is the date of separation, and the date of marriage.
Yeah. So you had touched on something earlier, Sherine, when you talked about debt often attaching to assets, and obviously we know it's not all assets that have debt attached to them. Your credit card debts might not be attached to any student loans.
So OSAP
the asset is the knowledge you got from school. Your credit card debts are not attached to any assets. Your line of credit sometimes is just money that you had to use. But for some things like there's other assets like your pension and what else can you
your
take?
Properties.
And maybe RSPs.
Investment properties.
That you can include a liability for. So I'm going to group them sort of in two categories. There's notional disposition costs. And from a legal perspective, there's certain events that happen that it's viewed as though you've disposed of your properties.
Yeah. Or that you will have to dispose of your property at a certain future date.
Yes. So if you have a match, and we're being very careful here because we don't want this to turn into kind of like a
free-for-all.
law, and not even a law class. So
okay.
In terms of the notional disposition costs, if you own a home and it's only in your name, then at some point in the near future, you may be selling the home. And so you need to include the cost of disposing of that home. The most obvious cost is your real estate agent.
So the commission. That's a significant amount.
And potential legal fees because the lawyers get paid to handle your real estate matter. So those are a notional disposition cost. And it's notional because you're not incurring it necessarily at that date, but it's a very realistic possibility that you will be incurring it. So that's the point of notional. It has to be at some very foreseeable date, not just 45 years from now, so something to consider. Then there's contingent liabilities.
Yeah.
So with contingent liabilities, it's almost just, the way I look at it, I explain that is, it's a kind of made up liability that
it's going to be contingent on something happening. So for example, like a tax event. So if you have an RSP that you're going to have to dispose of it, maybe even to satisfy an equalization payment, the reality is that you're going to have to tap into that asset and you're going to be incurred. The taxes are going to
the obligation exists, whether you're doing that now or later. Because even at some point when you're drawing that, so a pension, for example, is money that you're putting away for retirement for the most part. So there will be taxes at that future date when you have to draw on that pension. And so if we're sharing your pension today, we want to take into consideration that future tax liability. Yeah. In my mind, I just look at both contingent and notional disposition costs, contingent liabilities and notional disposition costs. I just say they're phantom taxes that just...
I'd say that they're a tax event to some extent. So if you have a pension, you're able to deduct a certain portion from your pension.
And that could be a
point of significant.
And it could also be a point of argument.
Certainly a point of contention.
Yes. So the easiest way to deal with that is to make sure that we get you, if it's being contended, then we get an actuarial report where they would look at your income at in the future and work their math magic and tell us what the appropriate discount rate would be. And, you know, it could range anywhere from 15% to 30%, depending on your income and a variety of other factors. So anyway, so those are not necessary. So the notional disposition cost and contingent liability sound a little bit up in the air because it's not like your line of credit where you actually have a statement monthly that you can provide to us. But not to worry, that's something that we consider. And if you're preparing your financial statement or putting together your document, you usually don't have these. You most likely don't have your actuarial report ready. You probably don't even have anything from a real estate agent saying this is what their commission is going to be. But we would usually,
oftentimes we generalize it unless there's a dispute, and then we can get into the specifics.
Yes.
Another thing is capital gains tax. So if you have an investment property, you're entitled to account for capital gains tax. And the reason is because if you've purchased this property, it's not even it's a more than a realistic tax event. You will be paying capital gains on that investment property. Mm-hmm. And so you definitely want to take into account, we would take into account how much you paid, and then we at the rate of selling and, you know, what it's gone for. Let's just say even you had tax, a capital gains tax that was actually payable prior to or just on the date of separation, you were selling a property. That's easy enough to figure out.
Yes.
So something like that would be a debt as well.
Yeah, that's a very good point. So so any debt or liability that you have is we need to disclose that. Okay. So now that you know that you need to disclose all of your income, all of your assets, and all of your debts and liabilities, what are the consequences for not disclosing these, right? So generally, it's kind of everyone knows that you have to do this.
Yeah,
okay?
It's your obligation. I think a lot of people are like, well, I don't want to disclose it. I'm like, well, if you actually have an obligation to under the law. And I think a lot of people, some people are very surprised by that, especially basic income disclosure. You know, where, you know, providing the last 3 years of notice of assessments, whether you like it or not, unfortunately, that's the basic requirement.
It is. All of these things we're telling you, you just have to do. And as I said, trust that even though you provide the disclosure that we're not necessarily, you know, going to hand it over to the other side and just gift them all of these assets that you've worked so hard for. If they're entitled to it, obviously, but our job is to make sure that you're protected. The other side, you know,
is aware, and we're abiding by the law that's in place.
So if you don't meet your disclosure obligation, the other party on a motion can get an order that you provide this disclosure, and well, if they have to bring a motion and they're successful, chances are you're going to be paying costs. Yep. Now, there's times, having said that you must disclose, I just want to add that there's times when it might be appropriate for you not to disclose.
Yeah.
But we understand those are the exceptions, not the rules. So I'm going to give just one example, and there's a whole host of them. If you're, say, a shareholder in a corporation with other partners, sometimes more often than not, those partners may not be comfortable with you disclosing the financial statement of a private company.
Yeah, unless you get an order for that disclosure.
But even when you do, you want to be careful when you're getting that order. If you're the lawyer for the party that doesn't want to disclose, you can ask for the order for it to be sealed.
Yeah.
So the point I was trying to get there is there's times when a person is refusing to disclose, not because they're trying to not meet their obligation, but because it would affect the interests of other people that are not part of the divorce. So in those cases, we would find ways around it. And usually it would just be an order sealing. It doesn't form part of the records. Mm-hmm. We would have, you know, it might mean that we have to meet at a common location to actually look at the physical documents. We might not be allowed to make copies, things like that. But obviously it has to be reasonable. And the other side really needs to show that there would be other parties besides themselves that would be prejudiced if they
didn't have that disclosure.
If we got all that disclosure, right? So, when you get that order that you have to provide disclosure, the party is successful, you have to pay them costs because that's just kind of the way it works. And if you proceed to fail to obey that order, well, some of the things that could happen to you include, more orders for costs, an order dismissing your claim, an order striking out, your application, your answer, anything,
anything like that you would not want to happen could happen from literally failing to disclose your financial disclosure. So and I mean, this is usually in the case of not consistent non-compliance. They can bring a contempt motion. Things that you definitely don't want to happen. Yes. So please disclose your financial disclosure unless given the circumstance.
Look at in simple cases where people don't disclose their income, not because they're hiding anything, but just because they don't feel like it, like they're exhausted, it's too much trouble, they haven't done their taxes, whatever reason, and they get income imputed to them.
Yeah, so you definitely don't want that.
It's so difficult to change it. And what's so sad is more often than not, the income that's imputed is more than their actual income.
Yeah.
So now you're stuck paying support at a higher amount than you would have if you had just disclosed.
Yeah, it doesn't go away just because you didn't provide your disclosure.
That's a good way to put it.
Just so you know, the court has mechanisms in place for this very reason, that even if you don't disclose your income, it actually might work against you. Just like you said, they will impute a higher income and you'll be paying support from an income that you don't even earn.
Exactly. So
all because you didn't want to disclose your income, thinking that maybe the support claim would go away. I can tell you from circumstances that will not happen.
Yeah, exactly. Well said, Sherine. I couldn't add to that. So I think that about wraps it for today. Is there anything you want to add?
I think we've covered everything. Thank you so much for listening and bearing with us.
Yeah, and good luck getting all this disclosure together. Remember, disclosure. Those are the 3 rules in your family law matter when you have a claim for support or property.
Thanks for listening and joining us in the AP Legal Zone. We hope you enjoyed this episode. You can find more episodes by searching AP Legal Zone on anywhere you watch podcasts. Be sure to subscribe to our podcast today so you can stay connected with any updates and get notified about any new episodes.